Hello everyone, my name is Kulsoom Farhat Khan. I am a student of law at Institute of Law Nirma University. Presently I'm doing an internship at Amikus Qriae, and today I will be talking about law of phone tapping in India. So let's start. So phone tapping is basically considered has led actually to infringement of right to privacy of an individual. In India, there are statutes like Indian Telegraph Act 1885, and as you can see on the screen, it defines telegraph as any appliance, instrument, material, or apparatus used or capable of use for transmission or reception of signs, signals, writing, images, and sounds or intelligence of any nature by wire, visual, or other magnetic emissions, radio waves or Hertzian waves, galvanic, electric, or magnetic means. So it gives a very wide and inclusive definition. So, as per the Act, no private individual has the right to incept or to do the phone tapping of an other individual. It is in the hands of only the government. So wiretapping is basically of two types. First is passive wiretapping, and the second one is active wiretapping. So the second one is the one which is illegal interception, and for this, under Section 25 of the Telegraph Act, it has been stated that there shall be a punishment for 3 years to the person who does illegal and unwarranted phone tapping. The act of telephone tapping affects the right to privacy of an individual, as I have said before, as well as the right to freedom of speech and expression. Both, as we know it, are fundamental rights under the Constitution of India. Article 21, which gives protection to life and liberty, can allow only such legislature made law which meets the constitutional requirements and applies a procedure which is just, fair, and reasonable. In a plethora of judgments, right to privacy has been held as an integral part of the right to life and personal liberty. So let's look upon what is the present scenario in India. So the Telegraph Act, as we have been discussing, uh, this is the act which regulates the phone tapping or the wiretapping in our country. The court mentioned at that time two statutory preconditions for the exercise of the power to intercept either the occurrence of any public emergency or the interest of public safety. These are the two scenarios in which the interception of communication can be done. So the conditions and grounds are not solely sufficient to control right to privacy. That is why court, in the case of PUCL, laid down detailed safeguards designed to check arbitrariness in the issuance of telephone tapping orders as follow. It directed that telephone tapping orders will not be issued except under authorization by the Home Secretary of the central government or of the state government. Order should indicate the kind of communication which is to be tapped. So the order passed by the Home Secretary was to cease to have effect at the end of 2 months from the date of authority, though it could be renewed for 6 months. A further direction was also given that original order would have to be reviewed by a committee consisting of cabinet secretary, law secretary, and secretary for telephone communication at the central level, and also a corresponding committee at the state level. And if it considers that there has been a contravention of act, it will set aside the order and also destroy copies of interception material. So phone tapping is definitely a threat to the right to privacy, as we have seen, or obviously when conducted in an unauthorized manner. The baseline is that only the competent authority may authorize the government agency to intercept for the purpose specified in Section 69 of the Information Technology Act 2000. So now we shall discuss the procedure which needs to be followed while obtaining orders in remote areas. So wiretapping is not a problem only in urban areas or in big cities, but sometimes it takes place in rural areas as well. We all know the ground reality of such areas, so obtaining prior directions from authorities is not practical. For securing remote areas from such activities, Interception Rules 2009, however, made an exception as In such cases, it would be permissible to carry out interception after obtaining the orders of the head or second senior most officer of security and law enforcement at the central level, and an authorized officer not below the rank of Inspector General of Police at the state or union territory level. Um, the order must be communicated to the competent authority within 7 working days, failing which the order would lapse. It is mentioned that any kind of interference or interception is only permissible if it is neither arbitrary nor unlawful. So, what are the powers of the government? What do the privileges lie with the government? So, the government has interceptive powers to extend the mobile telecommunications. Government's Department of Telecommunications was the sole licensing authority in India for private operators offering wireless services. The ministry has vested the authority on the agencies under Section 69 of IT Act, which is similar to Section 5 of the Indian Telegraph Act, and Rule 4 of the IT Procedure and Safeguards for Interception, Monitoring, and Decryption of Information Rules 2009. The central agencies authorized to carry out telephonic interception include the Research and Analysis Wing, the RAW, Intelligence Bureau, Directorate of Revenue Intelligence, CBI, Central Bureau of Investigation, NIA, National Investigation Agency, NCB, Narcotics Control Bureau, Directorate of Enforcement, Directorate of Signals Intelligence, and the CBDT, Central Board of Direct Taxes. In addition, similar powers have also been provided to the state police forces, as stated in Section 5 of the Telegraph Act, where the government can order interception of communication and reasonable restrictions can be imposed on the right to privacy in the interests of the sovereignty and integrity of India, security of state, friendly relation with foreign states, of public order, or for preventing incitement to the commission of an offense. So, let's now look upon how IT Act can play as a tool to preserve the privacy of an individual. So it's a digitized world as we know it. To protect right to privacy, nonetheless, the Information Technology Act provides comprehensive protection of data and prescribes stern punishment for its breach. So, talking about privacy, then IT acts as a safeguard in situations where someone violates the right to privacy of an individual. By any means under this act, we can't include or blame the government or central agencies for invasion because the government follows the procedure stated in the PUCL case. Analysis of the Supreme Court's decision on various cases brings forward certain areas that cover the protection of information as part of the right of privacy. One of the areas in Section 69, which empowers the central government or the state government, as the case may be, or any of its officers specially authorized by those governments, be to exercise powers of interception under this section. Similarly, the respective state secretaries in charge of home departments of the various states and union territories are designated as competent authorities to issue directions with respect to the state government. Phone tapping and right to privacy with respect to Indian judiciary. At the time of the drafting of the Indian Constitution, there were limited examples of codification of the right to privacy. Common law, for instance, never mentioned clearly about privacy doctrine. Jude Cooley explains the right to privacy as a synonymous of the right to be let alone. The question whether interception of telephone tapping of conversation constitutes a serious invasion of an individual right to privacy was considered by the apex court, and in its ruling agreed and stated that wiretaps are a serious invasion of an individual's privacy. The process related to the right to privacy began in Khadak Singh versus State of Uttar Pradesh. The right to privacy here was conceived around the home and unauthorized intrusions into homes. The court recognized the right to the people to be secure in their persons, houses, papers, and effects. Later on, its recognition by the court expanded the right to privacy beyond the physical realm. The PUCL court further evolved the notion of privacy to include personal communications, holding that the right to hold a telephone conversation in the privacy of one's home or office without interference can certainly be claimed as a right to privacy. Um, In this case, the Indian Supreme Court declared that the right to hold a telephone conversation in the privacy of one's home or office without interference can certainly be claimed as right to privacy. A telephone conversation is an important facet of a man's private life. The court thus ruled that telephone tapping would violate Article 21 unless it was permitted by the procedure established by law, and that it would also violate the right to freedom of speech and expression unless it came within the restrictions permitted by Article 19, Clause 2. Further, the Supreme Court clarified that even where the law clearly defines the situations in which interception may take place, this law must have procedural backing to ensure that the exercise of power is just and reasonable. The protection is not for the guilty citizen against the efforts of the police to vindicate the law and prevent corruption of public servants. It must not be understood that the courts will tolerate safeguards for the protection of the citizens to be imperiled by permitting the police to proceed by unlawful or irregular methods. In the present case, there is no unlawful or even irregular method in obtaining the tape recording of the conversation. Right to privacy can be restricted if there is an important countervailing interest which is superior to it, and if there is a compelling state interest to be served. So, we come to the conclusion of the topic, and it can be very well said that in the present times, India does have sufficient legislation which regulates the interception of communication. Overall outcome of the article is that communications surveillance constitutes an important component in maintaining the sovereignty, security, and integrity of the state. And if ordered according to a prescribed procedure, then it is not unconstitutional. Many judgments came up regarding legality of phone tapping in India, and they all held that it can be carried out in accordance with the proper guidelines and procedures stated in the POCL case. For now, the Indian public has gradually become aware of possible privacy violations that could be caused by technology, and they know for prevention and investigation of crimes, or in maintaining the sovereignty, integrity, and security, or if such information discloses clues and evidence of a crime or scandal, they have to be pursued. So it's not illegal. The proper procedure needs to be followed. Lastly, IT Act is available for the precaution of our privacy. With this, marks the end of the presentation. Thank you very much.